First of all, we're going to be hearing from Dr. Joe Purshouse, who is the Associate Tenant here at Garden Court North, and he's also a Senior Lecturer in Criminal Law and Justice at the University of Sheffield. His research focus is on the disruptive impact of innovations in technology on criminal justice process and policing. And last year he published, or he was joint editor and author of a book with Routledge, which was entitled Privacy, Technology and the Criminal Process. And he'll be doing a case law update for us. And then after that, we're going to hear from Lily Lewis, who is a barrister here at Garden Court North, and she has a multidisciplinary human rights and social welfare practice. She specialises in inquests, public inquiries and public law, and she's currently instructed in the undercover policing and UK COVID-19 inquiries. And she'll be giving us an update, I think, focusing on the undercover policing inquiry. Right, so if I could start then with Joe, who's going to be giving us the case law update.
Thank you very much for that, Camille. Yeah, I've divided my portion of the presentation into the subheadings that are on the next slide, I believe. Thanks, David. The next slide, please, might be triggering for all of us who've lived through the pandemic, so apologies for that. Yeah, going to look at data and surveillance, torts and misconduct and vetting. Obviously, it's going to be a bit of a whistle-stop tour through some of the main developments that I've seen in this area and parts of these areas of the law that have interested me in particular. And I've tried to approach this exercise to make it useful for persons who engage with Garden Court North's work, but also I know that there's some students and academic colleagues on the court. So I've tried to frame this so that there's something for everyone. And then once I've done my portion, I'll hand over to Lily. So next slide, please, David. In fact, I think you can just skip on to the one after. Brilliant, thank you. So the first sort of category of updates, that's one that's close to my research interests, is facial recognition technology. The now sort of famous case of Bridges versus the Chief Constable of South Wales Police held that the South Wales Police's operation of what's known as live facial recognition technology was unlawful. Basically, in that case, Mr. Bridges was a political campaigner. He'd been scanned by facial recognition cameras that were posted in public vicinities in Cardiff. What the police were doing, we were looking for people who were on a watch list of images that they'd compiled through the face matching technology. Mr. Bridges was not matched, but he brought a claim arguing that the use of this technology was unlawful. It wasn't constrained by an adequate legal framework for human rights purposes. It had equality law implications to it, and it was a breach of his data protection. It was processing his data and personal information unlawfully. The court found in favour and that the claim could succeed on these grounds, that there was illegality in the police's use of this technology. But the case was received quite well by the police. There was no appeal, despite being quite an important point of law. And in public comments afterwards, several police forces intimated that they could really work with the judgment, and that was probably because of the way the case had been reasoned. First, there was no finding that the police needed a sort of statutory legal basis to use this technology. They could rely on their broader common law powers. And second, compliance with the legal framework could potentially be achieved through editing or changing or amending the police's own internal guidance and regulations on the scope of operations of live facial recognition technology. And when focusing on the impact of this, whilst the court found that Article 8, the right to respect to private life, was engaged, they said that this was quite a low-level intrusion with Mr. Bridges' privacy rights, because he'd just been scanned momentarily. His data was actually deleted by the machine quite quickly. So that's where we are on live facial recognition. And in 2022, the College of Policing published an authorised professional practice, which added to the regulatory framework on live automated facial recognition. A number of forces have continued to embed this as a tool within their surveillance operational armory. So there may be further legal challenges in the future, but that remains to be seen. In 2023, there were two very different but important in their own ways cases involving different ways of using facial recognition technology. So in Clearview AI versus the Information Commissioner. Clearview, for background, was a company that scraped billions of images from the public-facing side of the internet and compiled a massive sort of, think of it as a facial recognition search engine. Clients of Clearview could upload images and identify the persons on those images. Clearview pitched its technology on a subscription basis to law enforcement agencies. However, it was found as a matter of fact that this was a US-based company and it didn't have any UK or EU clients, which was really important into how the case was decided. The case arose after the Information Commissioner issued what's known as a monetary penalty notice to Clearview AI, to this company. And the basis of this was that it was going to be inevitably processing images of people from the UK, of EU and UK citizens. And so in that sense, it would engage domestic data protection regulatory frameworks. The first tier tribunal considered Clearview's appeal against that enforcement notice. It did find, as a matter of fact, that there would be such processing, that even though it was impossible to know how many images of people in the UK, say smoking or engaging in behaviour that would be processed and identifiable to individuals, couldn't know how many such persons were on it, that had happened. However, the first tier tribunal basically concluded that the Information Commissioner's Office didn't have jurisdiction to issue the notice because Clearview was processing information as a company based outside of the EU and outside of the UK, and all of its customers, the law enforcement agencies that were involved, were outside of the UK as well. So it highlights the importance of jurisdiction, particularly as large technology corporations that might use facial recognition scrape images from people in jurisdictions that are outside the remit of the UK data protection regulatory framework. There may be further developments in this area as well. The Information Commissioner's Office sought to appeal this decision, and the Information Commissioner publicly expressed the view that basically, because Clearview was providing a service to foreign governments for profit, it shouldn't have been classed as a law enforcement processor itself. It was actually a private company scraping personal data of UK citizens and using that for a commercial purpose. So it shouldn't have been classed as exceptional law enforcement processing, as Clearview was scraping and using the data. The second facial recognition case that I'm going to talk about is Glukin versus Russia. This was a case before the third section of the European Court on Human Rights, and it was focused on the Russian police force and law enforcement agencies' use of facial recognition to identify and arrest an individual who was participating in a solo demonstration on the Moscow Underground. Now, this occurred before September 22, which was the date on which the Russian Federation ceased to be a party to the convention, and so the European Court still had jurisdiction over the matter. There are a few important features of this case. I think it highlights a bit of a divergence from the reasoning that was set out by the Domestic Court of Appeal in the Bridges judgment. First, the court found that there was a breach of Article 10 in the arrest of the applicant, and that was because he was expressing views that were legitimate in a democratic society, and there was a lack of legal framework governing his arrest. That wasn't really to do with facial recognition, but the Article 8 issue was, and the court found there were several activities that interfered with the applicant's right to respect for private life. First, the Russian state had collected and stored screenshots from his from the internet, from a Telegram channel that to compile images of the applicant and then use facial recognition technology to search for him. They also used a live version of the technology. So after they'd identified who the applicant was, they tried to arrest him at his address, but he wasn't there. So they used live facial recognition to identify him through the CCTV network in Moscow and locate and arrest the applicant. What the European Court found was that this use of the technology was actually highly intrusive, and you could contrast that with the finding in Bridges that the processing of sensitive information to identify an individual in the sort of criminal justice context when someone's exercising their democratic rights was seen as a serious interference, and that affected the proportionality analysis at stage 2. There is also some other features of the reasoning that are quite interesting. First, the Russian government didn't admit that they'd used facial recognition technology in this case, but the court basically found that the facts just indicated that there was no realistic other way they could have identified who the applicant was, where they lived, and tracked them in Moscow without using this. So they eased the burden on the applicant to show that this surveillance had been used, and I think that's quite an important point to note, given how technologies are advancing and how they can monitor and identify people at a distance. So the court was happy to ease the burden in that case. So those are facial recognition then. Another area within data and surveillance that I want to talk about is a data breach case of Driver and the Crown Prosecution Service. This involved a local politician who was suspected of being involved in local government corruption and was subject to a police operation against a group of local politicians called Operation Sheridan. His file was transferred to the police to consider charges, and basically a concerned citizen had emailed the police and the CPS and requested information about Operation Sheridan. A CPS lawyer responded to this message and basically said that a file had been transferred from the Operation Sheridan investigation to the CPS for them to consider. Even though that didn't specifically identify Mr. Driver, he was indirectly identified, as it was well known publicly that he was associated with Operation Sheridan. And the citizen who'd asked for this information publicised it and did name Mr. Driver as part of that. So the court found that first, this sharing of limited information about Operation Sheridan was sufficient to breach data protection law. It wasn't a GDPR claim in the classic sense. It was, they found that the decision about charge fell under law enforcement processing, for the purposes of Data Protection Act 2018. However, there was sufficient information there to link this to the individual, and there weren't necessarily any clear justifications for disseminating that information to a member of the public. So there was a breach of the first data protection principle around lawful processing for law enforcement purposes, and there were other issues and breaches as well within that. As to remedy, the judge made a declaration of illegality in relating a breach of data protection law and also awarded compensation. However, the court was quite critical of the way that the claimant had sort of hammed up the effect of this breach upon him. They found it was probably going to cause a very modest degree of distress, notably because this information was already widely reported in the public. It was well linked to Operation Sheridan prior to the breach. So he was awarded just £250 of damages when he claimed initially £2,000. Next slide, please, David. Okay, so moving from breach to retention of information then. This has been an area that's been quite active in the last few years. And for those who don't know the history of police retention cases, they're often a source of tension and divergence between the domestic courts approach and European courts of human rights approach to assessing whether retention is lawful and whether it breaches privacy rights. That's perhaps set out most starkly by the leading case on this from Essen Marper, which, when it went through the domestic courts, was a arrestee DNA retention case. 16 domestic judges basically said there was no violation of the privacy rights of the claimants in those cases when they had their DNA and fingerprint data indefinitely retained by the police after an arrest. The Strasbourg court, the European court, basically found unanimously that there was a violation. And without going into the 10 years of jurisprudence that have developed since that time, there are some cases here that give us a bit of a lay of the land. The first is YZ versus the Chief Constable of South Wales. Here, the police refused to delete an individual's personal data from the police national computer after he was acquitted for committing a rape against his wife. So it was non-conviction information, and the claimant sought judicial review of the decision to continue to retain that on police databases. The judicial review failed at first instance, and in YZ, the Court of Appeal was considering an appeal of that decision. So the appellant basically submitted that the judge had applied the wrong test here. They applied a test of rationality, which lends itself to judicial review and not a merits-based analysis. They said instead there should have been a focus on the test in data protection law for sensitive personal data processing of strict necessity. This argument was dismissed, and the court also found that there was no breach of Article 8 in the continued retention of this acquittal information. Such claims are really rarely going to fail on the in accordance with the law limb of Article 8.2. The police forces have come a long way since Essen Marper in developing guidance and policy documents, and there's a broader legal framework which, as long as that's adhered to by the police, they should be complying with Article 8.2 with the retention of this information. On justification, the court articulated some quite key points. First, the burden was on the applicant to show a positive basis that the deletion of the information was appropriate, or that there'd been a violation of his rights through the failure to delete. The court was satisfied that National Police Chief Council's guidance established a clear process for requesting deletion of such material, and They also noted that if the police were required to delete that information, they would be the only agency that had this information that would be required to delete it. So it failed on the justification point. And what another point for practitioners that might also be relevant is that when assessing whether it was justified, the court found that when approaching proportionality and necessity for Article 8.2 purposes, the basic same analysis applies as when considering whether there was a breach of data protection law, and that's the four-part proportionality standard set out in the case of Bank Milat, which I'm sure practitioners will be familiar with. The second case is AB versus the Chief Constable of British Transport Police. This case involved an individual who was on the autism spectrum disorder and had an Asperger's related condition. To help with this and to ease his anxiety when traveling in public, he would rub fabric between his fingers. In 2011 and in 2014, 2 complaints were made about the respondent to the police by women who had sat near this individual on public transport. Both allegations were investigated by the British Transport Police, but AB was not charged with any offence. The police sought to retain the non-conviction information in relation to these allegations, and that constituted a record in a police officer's pocket notebook and what's known as an occurrence summary report, which is just a summary of the incident stored on the police national computer. AB claimed that this was unlawful and attempted to challenge the retention on these grounds. What he focused on was that the information recorded that he was touching himself inappropriately on public transport was inaccurate. It wasn't factually correct. He was rubbing material together in relation to managing his autism condition. What the court found was that didn't matter. When assessing whether the information was accurate, what mattered was, were the police accurately recording what had been reported to them? And if they were doing so, there was no breach of the 4th data protection principle on accurate information recording. What the court did find, though, was that there was no real justification to continue to retain the information in this case. It would constitute a disproportionate interference with Article 8. Although generally retention of non-conviction information is generally seen by the courts as being minimally intrusive. In this case, the court said there were exceptional circumstances around the impact it would have on the individual and the distress it would cause on an ongoing basis. And so there wasn't the necessity or strong justification for retention of this information. The final case I was going to touch upon is the case of Strain. This again involved a sort of non-conviction intelligence report relating to records stored on the Greater Manchester Police's databases. The report related to an account of 2 police officers visiting the claimant's address in 2019. They visited because she'd threatened to self-immolate outside of a police station in protest at the fact that the police were also maintaining a record of a past allegation that was recorded against her of domestic abuse. She complained that there were inaccuracies in the report, but these were amended by the Chief Constable or on behalf of the Chief Constable. Strain continued to pursue judicial review of the Chief Constable's decision not to remove these reports, which she viewed as highly stigmatising. Basically, this was rejected at first instance, and then the claimant appealed that decision. The grounds were that there was an arguable case that the data that was being retained in breach of the Data Protection Act, and the Chief Constable should have agreed to erase it, essentially. The court made some interesting general findings. One of the first was that this was a judicial review that was brought, but there was actually an alternative remedy that ought to have been sought under data protection law. So Section 167 of the Data Protection Act provides for a data subject who alleges that there's been an infringement under their rights to apply to the county court or the High Court for a remedy, and could apply to secure a data controller, in this case the police's compliance and deletion of that record. This remedy was not pursued by the claimant initially, and so as there was an alternative to judicial review available, that should have been sought in the first instance. On the substantive issue, the administrative court was held not to have erred in refusing to delete the information. There'd been no public law error in the Chief Constable's initial decision, as there were serious matters in the claims, and the non-conviction information was viewed to be justifiable to retain. So the appeal was dismissed in strain, and there's some, I think, important points of principle emerging from that. Summarising these three cases, a few things that are clear are: first, that the police can retain non-conviction information generally for quite long periods of time, applying the sort of, there's a 100 years rule, and there's an almost implicit presumption in favour of retention for the duration of that, with exceptions being applied on a sort of case-by-case assessment. Yeah, and there's been a few legislative developments. I don't want to spend too much time on these, but there's the Data Protection and Digital Information Bill. This does two key things for those interested in data input and surveillance in policing. The first is that it will enable law enforcement officers and authorities to retain biometric data obtained from foreign governments or partner agencies for longer periods of time than they can currently. And second, it's going to abolish the office of the Biometrics and Surveillance Camera Commissioner and put a lot of the oversight duties of that Commissioner's office under the remit of the Information Commissioner's office. There's a report linked on the slide, and I believe the slides will be shared after the presentation, that is critical of this measure in particular, because essentially it boils down to surveillance and biometric data processing being about more than just data protection and information management issues in a police surveillance context. It can have broader human rights and democratic society based implications, and might require particular expertise as these technologies develop in their complexity and continue to be used. The Investigatory Powers Amendment Bill basically implements many of the recommendations in an independent review of the Investigatory Powers Act 2016 from Lord Anderson. I won't go into detail on all of those now, but there's an NGO joint briefing of a number of interested rights-based campaign groups that have complained that this may set a low bar and open up the powers of security services and law enforcement agencies to collect bulk data sets of private information and gather the whole high stack of publicly available information about people and their communications in order to search for serious incidences that might threaten national security. Next slide, David. Thank you. So in terms of torts, the main things I'll draw attention to first, that in terms of duty of care, this is an area of the law that we've had a few quite landmark cases in the last 10 years. Case of Michael at the Supreme Court, Robinson, which focused on police duty of care, but actually changed the law of negligence generally by setting in its proper place the Caparo test, the three-part test for the existence of a duty of care. Sorry, I believe I accidentally muted myself there. These cases are interesting because they pull in slightly different directions. So in Tyndall, there was a traffic accident, a driver crashed, and a passerby tried to warn other users that there'd been an accident in the road. The police arrived, put up a go slow sign, and then as the passerby went to receive some treatment for his injuries. The police then cleared some debris off the road and moved away, but the car was still in situation on a dark, narrow road. The car arrived and there was a fatal accident after the police had left. The claimant argued that the police had made the situation worse through a positive act, and so were under their duty of care was engaged because they'd done a positive act to contribute to the accident. And in the alternative, they had assumed responsibility for the safety of the road at the moment that they took over the management of the accident. It was held in that case that these sorts of interventions, even if they're ineffective, are actually a failure to confer a benefit. They're an omission. They've failed to confer a benefit or do what the police should do to the maximum effect, but they don't give rise to liability in negligence. And briefly then, in Woodcock, the claimant was attacked by her ex-partner. She had an ongoing sort of history of intimate partner violence with this ex-partner who was loitering outside of her house. The police had been involved in the past and had put in place a sort of safety plan. Basically, the ex-partner brutally attacked the neighbour after loitering outside of her house, and a claim was brought because the police had failed to warn the partner that the ex was loitering outside of the house and looking quite threatening, despite being warned in a 999 call by the victim's neighbour. So they'd failed to protect from this act or discharge a supposed duty of care. The court held, the High Court in this case, that this was an exceptional circumstance where the police might have a duty in relation to their mission to safeguard the victim. The police's duty in this case was held to arise from them assuming responsibility for the victim's protection through developing that safety plan prior to the attack. This is seen as a sort of extension of where duties would have previously been recognised, because it creates a duty on the police to positively warn a citizen of danger from a third party. So it could open up the scope for bringing claims in negligence against the police where they're aware of a particular risk and have failed to obviate it carelessly. Both of these are then going to be subject to appeal, so it's an area that's going to continue to develop at the moment. It's really quite uncertain, I would say, what the scope of the police's duty of care is to prevent harm from individuals in dangerous situations. A wider development then is the recent case of Lewis Ranwell versus G4S and others. The factual background of this one is really tragic. Alexander Lewis Ranwell killed 3 men whilst suffering from insane delusions, to use the legal, not medical terminology. Lewis Ranwell basically believed that these men were paedophiles, which they were not, and was subject to criminal proceedings, which concluded with the finding that he was not guilty by reason of insanity. So he was able to raise an insanity defence. Following this not guilty verdict, or special verdict, Lewis Ranwell brought a claim in negligence against several health authorities and the police because they failed to prevent his attacks. He was arrested a few days prior to the attack. and was detained after attacking members of the public and subject to some evaluations by the relevant health authorities, but was released and then committed these killings. The defendants to this claim, with the exception of the police, applied to strike out the claims, relying on the illegality defence to a tort. They basically said that the claimant, Lewis Ranwell, should not be compensated for his own unlawful acts. This application for a strikeout was rejected, and the defendants appealed that decision. So this case was entirely novel. Before Lewis Ranwell, the courts had found that if someone was, say, killed someone but was found to have diminished responsibility, they would be blocked out from a claim in negligence against those who failed to prevent that offence through the illegality defence. But insanity is different to that, in that it's a finding that the person's conduct can be excused, even though they've done the actus reus of an offence. And it can be excused because the individual is seen as lacking culpability entirely. They don't have a criminal mindset. Lord Justice Underhill gave a really impressive overview of the development of the insanity defence and the illegality defence in tort and the relationship between the two, and ultimately found that, among other things, the illegality defence in tort will only block a claim where the the claimant has committed a crime culpably. So applying the earlier decisions on diminished responsibility and confining it to that. So people who are classed as an insane automaton are different to those who commit a murder under with diminished responsibility. There was also a dissenting opinion that's worth reading for balance in this case. Lady Justice Andrews viewed the fact that there was a criminal act as a bar on a subsequent claim of negligence, even if there was an excuse for committing the actus reus of the offence, and drew upon strong, what she viewed as public policy reasons not to allow an individual such as Lewis Ranwell to claim compensation against those who failed to prevent him killing. Next slide, please, David. And I'll wrap this up. One more. Thank you. So police vetting and misconduct. Aspects of police law can be topical, but it's rare we talk about something that's totally dominated Prime Minister's questions the day before. There's been a few developments in police misconduct, and that's perhaps an understatement. For our purposes, so the debate sits around post killings of Wayne Couzens and the crimes of David Carrick, two Metropolitan Police officers. Sir Mark Rowley, as the Commissioner of the Met, has essentially called for changes to the police misconduct process, essentially arguing that chief officers should be able to dismiss any police officer they don't have confidence in on grounds of misconduct. And this follows Baroness Casey's review, which found severe institutional failings across the Metropolitan Police that would require radical reform to root out officers who'd engaged in misconduct. He basically was expressing a frustration that decisions from misconduct tribunals were being overturned by appeal tribunals, which were chaired by a legally qualified chair who sat alongside senior police officers. So officers who would have been dismissed were being sort of reinstated. Two examples come from the Williams case and the Gutty case on the slide. The Williams case involved a senior officer who was convicted of possessing an indecent image of a child after her sister had sent it to her, seemingly to raise awareness of its existence and express alarm. The sentencing remarks in the Crown Court indicated that the senior officer who received these messages didn't get any sexual gratification from the images, but also that her claim that she hadn't known she'd been sent them was disbelieved by the jury. The second case involved an officer who'd been convicted in the Magistrates' Court of assault. So both of found to have engaged in misconduct were initially dismissed, but then on appeal, that was downgraded to a final written warning. The third case in this area from 2023, case of Victor, this basically has a point of principle about the distinction between police misconduct proceedings and police vetting. So in this case, the claimant, the police officer, had been involved in some aggressive and abusive behaviour. They were found to have been involved in misconduct, but not gross misconduct. But then subsequently, the police force engaged in a vetting exercise, and the officer failed vetting and sought review of that decision. The courts basically found that the two processes are different. They have a slightly different focus and a slightly different criteria that are applied, and there was nothing inconsistent with the decision made. Lastly, we have, this is a fertile area. The Home Office has basically published a document suggesting that they may get rid of legally qualified chairs or demote them to being a part of the panel rather than chairing misconduct proceedings. We have a new vetting code of practice, and the Angelini report was published last week and makes a series of recommendations around rooting out officers who've had any past involvement in indecent exposure or allegations of such. Recommendations for enhanced vetting of police officers, home interviews, psychological assessments, and improved data sharing between police forces. So probably much more to come on police misconduct in the coming years, but I'll conclude my presentation there.
Yes, so we've got one question here from Jessica Ashcroft for both Joe and Lily. What do you believe is the cause of increased attention on police misconduct? Do you think police officers' conduct is getting worse, e.g. by the need to abandon quality due to the need to recruit more police officers, or would you attribute more weight to the role of technological advances in informing the public of matters to which they may not have previously been aware?
Do you want to go first, Joe?
I can do. So, yeah, it's never going to be one thing when you're talking about a complex social trend, as we're seeing with more focus on police misconduct. Out of the two possible drivers that you've identified, I think technological advances is probably a bigger part of the picture. I don't know if there's that much about police recruitment, but I don't understand that there's been any major changes in the standards of vetting or training or anything like that that are required to be a police officer, any diluting. Maybe the pool of candidates is lesser, but I think often police misconduct is something that's entrenched in the culture of the police, and technology can play an important role in shining a light on that. If you look at something like the George Floyd case in 2020, if that happened 15 years ago, you wouldn't have had several recordings from different angles of HD resolution videos being distributed around the world within an instant of that sort of instance of police brutality. So technology can expose things that are happening and can provide an important counter to police narratives, which without the sort of video footage or without technology sort of piecing together what's happened, tend to be very powerful and believed by authorities and courts and things like that. There's lots of sociological literature on that. So I think technology is definitely a big part of increased attention and exposure of these issues.
Yeah, I agree with that. I've got very little to add, really. I mean, just to say on the kind of undercover policing inquiry example, I think more generally with some of these issues, what really worries me is how long it can take for these problems to come to light and then for changes to be made. So, in the UCPI, we're finding out about sort of unacceptable and unjustified undercover policing from the 70s. Only now, after kind of years of campaigning work and hard work by activists and journalists to bring these issues to light, and what was really clear in a lot of the evidence that we've seen so far is the level of secrecy around these activities. So I think, I mean, similar to Joe, I think technology can be really helpful in kind of bringing more transparency. But I think one of the things that has always really concerned me is just how long it can take for some of these problems to be exposed.
Thank you both of you, and thank you everyone who's joined us today. I think we're going to bring it to an end now because we're just past 1, but the slides will be available, and somewhere the recording will be available as well if anyone wants to see it afterwards, or has colleagues who want to see it afterwards. Yes, so thank you very much, Joe and Lily.